Welcome to the 5-Minute Update, a podcast of the Licensing Executive Society of the USA and Canada. I'm Dave Pausner. I'm here with Sanjay Prasad and Stephen Kavikoff for the pilot episode of this new podcast series. Sanjay, Stephen, and I are IP lawyers, and we're all members and volunteers of the Licensing Executive Society of the United States and Canada. That's an association that brings together IP and licensing professionals to network, collaborate, and discuss issues involving intellectual property, business, and law. You can read about us in the Licensing Executive Society on LinkedIn. Sanjay and Stephen, greetings. We are having fantastic, finally, weather up here in Boston. How are you guys faring in your locales?
Morning, Dave. Hey, Stephen. Good to be with you all. Things are good here. Another lovely day here in the San Francisco Peninsula.
Everything's just peachy here in Atlanta.
Good to hear.
And, just work as usual, but everything's going well.
Good. Things have opened up in Boston. I was happy to see people with no masks finally. So we've got a guest today. It's Derek Snetner. Like the rest of us, Derek's an IP lawyer. His focus with the Licensing Executive Society is consumer and mobile electronics. Derek, you're in, I was going to say Minnesota, but I think you're in Milwaukee, correct?
David, that's right. And sometimes for those of you who are on the coast, Minneapolis and Milwaukee get confused, but we're in Milwaukee, so separate state, closer to Chicago actually than to Minneapolis where I am. But Midwest is doing well, opening up, and yeah, we're enjoying some great summer weather now.
Great. So Sanjay, you want to start us off?
Yeah. So Derek, what's new in consumer mobile electronics from a licensing professional's perspective?
On the legal front, licensing front, though, I think might be interesting to just talk about the Google v. Oracle case. That case came out not so long ago, about 6 weeks roughly, and obviously a lot of discussion around the case has occurred, or in the copyright world, or among those who specialize in copyright law. But I think it also has an impact on licensing perspectives, because the background of the case really does relate to a situation where Oracle and its successor, or not successor but predecessor, Sun Microsystems, the owner of the Java copyright, the Java programming language, went to Google and said, "Hey, we'd like you to license the code." And so, licensing negotiations broke down, and then from that perspective, Google made a decision essentially to create their own API, and that's when litigation ensued. So, from the licensing perspective, what we have here is a situation where I think other prospective licensors and licensees need to be aware of the fact that there could be a new strategy out there, which is to say, hey, look, Supreme Court in its most recent copyright case says that I can copy certain portions of software, in particular portions of an API, create some of my own code, and that's a fair use, and I can do that for commercial purposes. So I think from a perspective of, hey, how does that affect my licensing program, it can have a big impact going forward. And I think from my perspective, that's something that members within LES really need to think about and be aware of, and understand that there could be a new strategy in play, perhaps more so than in the past, in light of what the Supreme Court has said.
It seems to me that also in other situations, if more code from the API had been copied, more of the declaring code, maybe the result could have come out differently. And the fact there was only, say, 11,000 lines or so, as opposed to, let's say, you copy the entire structure, sequence, and organization of the API, then maybe the fair use defense is not as likely to succeed.
So that's the end of our first episode. Thank you.
Thanks.
Thank you. I appreciate it.
Totally cool. Yeah.